Good morning, friends. Sat Sri Akal, Adab and Namaskar. This is my 205th video, and this series of videos will now be covering Ambala Cantonment. Now, we can call this an amazing case where a bungalow owner in resumption actually won through the government, or we can even put it as a discriminatory case, that why didn't the government go in for appeals in this case. So I remember this bungalow number 18, which was originally owned by Staff Road by Wing Commander Nagina Singh, son of late S.Bhgwan Singh, the survey number 108. Now this bungalow was issued a resumption notice, I think way back in 1975, and I remember this bungalow after the resumption was even sold to an HOR when Mr. Nagina Singh died and his son Kuldeep Singh inherited the property. So we'll talk of what actually happened in this bungalow. This bungalow originally is holding a site which is above more than about 9.94 or 10 acres of land. So a part resumption of 7 acres was done and the balance 2.94 was left as per a plan attached of the resumption, which is in my hand. Now friends, here I will talk, I had just spoken in an earlier video that why this judicial record. Now you will be surprised, this record of next coming videos actually came to me when I was digging into the judicial record of Ambala earlier than 1978 or I think 80. 1980 and backward, I went up till 1882. So I have documents and court cases since 1882 of Ambala Cantonment. I have the oldest sale deed of Ambala Cantonment, which is of 1836. So now this bungalow, when was given a resumption notice in 1975, was given a value of 17,485. As expected, Wing Commander Nagina Singh filed a suit for declaration in the lower court, number 72 of 75. Now what did he plead? Plaintiff number 1 had been a personal Indian Air Force officer. His wife is an housewife, and this bungalow, which is claimed to be an old grant, was actually allotted to him via an exhibit letter measuring 9.94 acres situated on Staff Road, Ambala, Cantt, having premises so and so. In 1967 he purchases this bungalow. Must be an owner there. So very important here. Now Wing Commander Nagina Singh is admitting the sanction and the allotment of this letter. In the coming I'll prove it what he has said. So now he is basically claiming what? The impugned notice by virtue of which Union of India resumed the property is illegal without jurisdiction, malified, ineffected on grounds. Plaintiff is the owner in possession of the suit property. The plaintiff improved the property. Now he renovated the property in question after purchasing it in 1967 and spent a huge amount, dig a water tank, construction, and the compensation of 17,485 is very meager. Though the structure of building is worth lakhs in 1975, the government cannot resume the property. He claims that Wing Commander Nagina Singh only has one bungalow, which is this, so it cannot be resumed. While the other bungalows, now this is very important, these are the same bungalow owners who actually sometimes talk and mimic about me that Ronnie ji, why are you raking up issues of various other bungalows in your cantonments? What is the article saying? Discrimination. Now look at what in 1975 Wing Commander Nagina Singh is saying. That the land, while the other such bungalows in Ambala Cantonment have not been taken or affected. So he is mentioning these bungalows also in his plaint. So everybody talks here when it comes to you. You can't let yourself die. You will always, it's a very natural phenomena. You'll say, why is the government leaving him, and her? And why take me alone? Even the 1970 policy of resumption which Sardar Swaran Singh made speaks it has to be a chunk or a full blot of bungalows so that the land can be put to specific defense purpose. That the land does not belong to the government, that in Ambala Cantonment in 1975 there is n number of land, surplus land which is lying unutilized by the authorities, and he even filed an application which is very normal under Order 39 Rule 1-2 for a status quo or a stay which is granted to him. Now what is the ministry replying to the plaint? That the jurisdiction of the civil court is barred under Rule 15 of the Public Premises Act 1971. This is very important. People don't understand it. You know, here the department says we have to initiate a PP Act after the resumption is given. So there, the scare, a lot of bungalow owners talk to me, Mr. Das, resumption notice is issued. What will happen? They'll barge in, army will just walk in after 30 days. They cannot. This is that section which speaks. Even in 1958 PP Act there was a section. So 58, 71, 77 PP Act when it was rebrushed, everywhere this section is there that after issuing a notice there has to be a PP Act proceedings under unauthorized occupancy. That the property in dispute has been with the Union of India as admitted. This is on rent with now. So that the plaintiffs were the owners only of the superstructure and on the land vacant site belongs to Union of India. So let's presume 9.9383 acres. Only the bungalow is of the owner and the rest of the land is already. So why give us this land? The plaintiff were the owners only of the superstructure. The compensation 4,885 has been paid and has been appropriately kept. There is a report from the JE South. I have that document because I picked up this attested copy from the judicial record room. I even remember that the new HOR of the bungalow owner wanted to get this file burnt there in the judicial record room. You know, like Surinder Kumar Vakil, he got twice his GLRs wanked away or, removed away from the Cantonment Board Sagar. And finally, that judgment became a Decorian judgment to us. So here also the new HOR tried to do, but when later it was told by the DRO and the HOR register that somebody has already taken an attested copy, it could not be done. This is where I say we bungalow owners are by ourselves not united. Now the bungalow says since it was in possession, so the bungalow already stands resumed, so the GLR would be converted into A1. Now on this a replication is filed and I appreciate Wing Commander Nagina Singh. Here he brings in Durgadas Sood's judgment of Kasauli that my bungalow number 18 falls within the House Accommodation Act area and there has to be not resumption but acquisition. No land belongs to the government or Ministry of Defence. Admission deeds were taken by the GOC Western Command under pressure or against my will. So he is talking of a board proceedings of 1843. This is very important in his case. Annexure O, which is of Record of Rights 1910, which says that the board in 1843 tried to take over these lands from the tillers or the owners of these lands, which it could not. It retried in 1865 and again this land was not given by the owners. So well, that's good. Very good, he brought in his Record of Rights. Whether now the issues framed were whether the order of resumption dated 14/2/1975 passed by the defendant is illegal, relief, no other issues pressed. So very important, there is no issue made in this suit for declaration of ownership. So only the issue made is that whether the notice, now this notice has to be seen. Now plaintiff brought in two evidences. One was Saptar Singh, who was an official from Deputy Commissioner's office, and he stated that till date 9,165.20 paisa is being paid to the kursi namas of the actual owners of the land which was acquired or taken up under the Wazibulas of 1843 to them. He brought in Mr. Verma, a civil engineer, who put the property's worth as construction to about 55,000, and he even rated the property to rupees 1200 per acre. So again this observation comes. So now we come to the observations. So Raj Singh case was quoted in this. What does that Raj Singh case say? That even if GGO has been applied on to us, it does not have a force of law. Then Durga Das Sood, Union of India case was discussed. Even Mr. Sangal's case from Jabalpur was discussed. So everything after being discussed as a force of law, whether or not on GGO, if we read these same terms, I feel with the provision, now the defendant is saying, now he says if you understand the General Clauses Act 1879, under section 24, it can be said that the provisos are to be, of the authority in question, have to be adhered. So now DW brings in the admission deeds of the one whom he brought from. So there are some 3 admission deeds brought on record, including of Wing Commander Nagina Singh. Now the observations finally settled on Hardarshan Desai's case of Jalandhar, where it was clearly said that part resumption cannot be done. So this case goes on. Now when we are actually reading this, on a contrary, these authorities on learned records of GLR and all were brought in, and the compensation by defendant was said can be always taken to the arbitration committee. Finally an order was moved and it was held that this notice is illegal. Relief, no issues much. So now documents which were annexed at a later stage was the GLR. Now there was another GLR which was dug in by me in the Cantonment Board office, and this GLR of bungalow number 18 speaks of a column which is 9, where landlord is written disputed. So this bungalow owner can actually make use of it. And later I remember Mr. Deepak and we, when we were digging into, now this bungalow number 18 has sale records from 1872 onwards, which was shared by Mr. Deepak to the bungalow owner. Now this is an example case why I say. Full evidence was led, documents were tendered. There was no appeal filed in 1978 by the MEO. Why? This is very important. Now I have the judicial record by the diary number 2366C of dated 6th November 2008. So I have all the official record, complete file of this. I even filed RTIs after this record to the station cell. Now I got a reply in 2010 admitting that yes, the bungalow of Wing Commander Nagina Singh was resumed. Later his son Kuldeep Singh sold the bungalow illegally without permission to the new HOR, and we know, we have pursued this case with the Defence Estate Officer, that why resumption proceedings are not taken forward. Very interestingly, after all these happenings, even the DO writes to me, Vide letter number 717 of 24th September 2013, that admitting that de novo proceedings have been initiated towards bungalow number 18 and resumption will be undertaken. So friends, we will have to come head on. If we are not going to come head on, the department at its own whims and fancies can do anything. This bungalow owner fought his case very well. Well, that's a part that the appeal was not filed. That is that is for me or you to decide whether this can be put in as a discriminatory case or whether the bungalow owner fought it and the department felt they are not in a position to take the case forward. So all these things is coming to the breach of the constitution here. Now documents, they file other papers. Now we need to understand there is a chapter in volume 2 of Cantonment Act 2006 by J.P. Mittal 23, which on page 700 to 722 clearly gives instructions for suit. So should there be a criminal proceedings or contempt proceedings filed against the people who connived and did not file an appeal for this case? Or there must have been a closure report given by the DG Lands then in 78, which till date the department is not sharing. So whose the delegated power to file appeals is need to be brought to court and make him answer. And like this, I'll bring in this discrimination in Ambala for next 7 cases you will see. And that's how things move forward, friends. We can all do it if we want. So you dig into your judicial records, dig into your registry records. Why can't we do it? Yeah? When I alone in 2007-8 could do it, and later I remember Deepak ji joined me, and I don't hesitate in saying, I even charged my bungalow owners who were at that time willing to take registries, I charged them 5,000 rupees for the registries because the association needed funds and we were spending money on the findings of these documents. Today, those same bungalow owners cannot get their registries even if they pay 10, 20, 40, any amount of money, because there is a thin line gone down the department that do not provide any document till the bungalow owner or the resident of the cantonment does not give the specific date of the registry or the court case. So today what all registries I have in my hand are worth some money. Why would I share it with any bungalow owner when the bungalow owners are not willing to do anything? They are not willing to wake up and get up for their own cases. So this is an exemplary case, bungalow number 18, Staff Road, Ambala, Cantt. Again I am saying we were old grants never converted into new grants. Thank you.